what you are saying that the respondent should have done is the full requirement under the provisions, the regulations. What is the minimum requirements of public participation?
Honorable member of the bench, I am privy to that case and thank you very much for guiding us there. The respondent may try to bring the reiterations of the holding in the case of Moot local basin community versus the permanent secretary minister for energy before the High Court in 2012 that stated that the test for public participation is its effectiveness. There is not one single litmus test for public participation. However, it is our submission that common law has come to fill in this lacuna in law recently in 2023 in the case of Sang versus the Board of Management Kenana School, where the court held that what matters at the end of the day is that the citizens be accorded a reasonable opportunity. A reasonable opportunity in two facets. A reasonable opportunity to know about the issue and a reasonable opportunity to have an adequate say. It is our position that both these provisions for a reasonable opportunity have been violated and allow the members of the bench to demonstrate. It is our submission that the committee members of Kasiri were not accorded a reasonable opportunity to know about the issue because Professor Bakari's team selectively disseminated information to the members. When you move with me, honorable members of the
Council, is there a requirement that everybody must be involved in the public participation?
No, it is not mandatory that everybody gives their views pursuant to the fourth element that was set out on the minimum requirements for public participation in the Wicon local basin case. However, a further and closer reading of the fourth requirement reveals that the respondent has to demonstrate intentional inclusivity and diversity. Intentional inclusivity, members of the bench. When you move with me to paragraph 17 of the fact sheet, we can infer the intention of the government. Here we see that they intentionally overlooked 53% of the population, honorable members of the bench. The intention of the respondents was not to carry out public participation in its totality.
Council, in the report, the professor discussed on how they had to come up with a craft of ensuring that any other person was involved, specifically on the aspect of the use of households to ensure that we have an integrated participation, and because they had some constraints to ensure public participation, including monetary constraints. So can you respond in line to that? Don't you think that this court should give them a margin of appreciation? That's one. Secondly, Article 26 of the ESPO Convention on Environmental Impact Assessment in a transboundary context clearly provides that individuals, which I agree with your submission on that, individuals should be given a chance to participate or engage, especially in matters that involve them. Can you address us on the practicability of involving individuals from another state in terms of public participation?
Thank you very much, honorable members of the bench. To start with the second question on practicability of involving the community members or the members of the state of Samira, these are matters of public participation. We are confined into the community members of Kasiri. The violations that the petitioner is bringing before this court is not on matters related to the rights of the people of Samira. It is the people or the community members of Kasiri where we are doing the mining project.
Do you think that the transboundary have in this context affected the individual of Samira? Yes or no?
It did.
It did.
Yes.
And the ESPO Convention provides that those who are highly likely to be affected by any project, specifically the ones that they have environmental issues, do you think that they should have been involved if they were highly at risk, especially in the context?
In that regard, allow us members of the bench to answer that question on our submissions for the third issue, which shall be canvassed by the co-counsel. In seeing that you have asked quite an engaging question on the financial constraints of the respondents, I think a discretionary 1.5 minutes to address that issue. Thank you for your generosity, honorable member of the bench. I do take note of the fact that the respondents faced various challenges as was written out in the report. However, members of the bench, common law has dealt with such matters and dealt with them fairly. Allow me to reiterate the Court of Appeal's decision, which is binding before this honorable court in the case of Minor versus Director General Nairobi Metropolitan Services, where the court, in emphasizing the irreversible nature of loss and damage that is usually incurred in environmental matters, stated that any obstacles or constraints that are felt or dealt with by the respondents ought to be overcome promptly instead of being used as a justification to cause environmental damage. We do not see the government in any case trying to carry out public participation in a better manner.
Are you sure about that? Because in the report, specifically the second paragraph, we are told they developed a multi-channel communication approach, including local radio broadcasts, public announcements, and collaboration with the community leaders. When the technique did not reach every individual, they feel that it demonstrates good faith, which is what you are alleging, does not meet the criteria. So don't you think that was enough? Because the requirement is that you should acknowledge other levels of public participation, other innovative levels.
Much obliged. And the petitioner.
To just align to that, there's a case in Kenya, John Rayamon, and former favor that the Minister for State for Provincial Administration, which clearly reiterates the same thing. It's actually a court of appeal case. We have the Mukule providing that the body conducting public participation is allowed to be innovative to ensure practicability of the public participation. We're taking that we should give the respondent the margin of appreciation in terms of the innovative measures provided by the presiding judge.
Much obliged to answer those questions, members of the bench. And as the petitioners, we are not contesting that public participation should be carried out in an innovative and malleable manner. Should this court find that the population assessed was sufficient, it is still our assertion that adequate public participation was not carried out because Professor Bakari's team selectively disseminated information. Those that were reached, honorable members of the bench, pursuant to paragraph 15 of the fact sheet, were not made well aware of the potential risks.
I wonder how radio broadcast is selected unless you tell us this community does not have access to the information. Then I wonder how that communication and publications through the radios are selected.
Much obliged. Allow me to clarify. Not selective in terms of the numbers, but selective in terms of the information that was disseminated. When you move with me to paragraph 15 of the fact sheet, we see that Professor Bakari's team left out or failed to inform the community members, which now they had reached the 47% of the potential risks involved in implementing the mining projects. Allow me to reiterate the holding in the case of Save Lamu and 5 others versus NEMA and another in 2019, where the court held that under paragraph 24, public participation for it to be effective must be accompanied by appropriate access to information. This involves the potential risks involved and also the potential benefits from the project. Further, in the case of Omar Salim versus Biblical Development Limited, under paragraph 28.
And so because of time, because we should be concluding.
Pursuant to the bailiff, I am informed that I still have 2 minutes, honorable member of the bench.
You were added 2 discretionary minutes a while ago, so conclude the submission.
Thank you, honorable member of the bench. Seeing that the Professor Bakari's team selectively disseminated information, we plead with this court to find that the public participation carried out by the respondents in this matter was not effective. With that, honorable members of the bench, I have come to the end of my submission, and I cede the floor to my co-counsel to buttress the position of the petitioners on the remaining issues, as well as administer our prayers. Thank you.
Your Honors, the respondents have done the unthinkable. They have spat on the faces of the citizens of Malindi and the international community at large. In light of the devastating and adverse impacts of the climate change, what is expected of them is to realize Section 3 of the Climate Change Act of 2016. Your Honors, they have disregarded this and instead emphasized more on economic development while disregarding the environmental vulnerability of Malindi, leading to the death of more than 200 people and the displacement of many more. Honorable members of the bench, my lords and my lady, counsel on record is Cyrus Karaoke, the second counsel appearing on behalf of the respondents. I intend to take the 13 minutes allocated to me to dispense with the merits of the second and the third issue presented before this court. Unless the bench directs otherwise, I wish to proceed. Your Honors, the second issue pertains to whether Tamu industry can be held liable for its contribution to greenhouse gas emissions, environmental degradation, and for exacerbating the climatic vulnerability of the region, particularly with regards to the floods and landslides, as well as the health impacts resulting thereof. Your Honors, it is our submission and position as the petitioners that they indeed can be held liable. In light of this, we will argue in two links of argument. That firstly, the second respondent disregarded the precautionary principle, and that secondly, the second respondent grossly violated the Constitution with regard to environmental laws. To my first limb of argument, Your Honors, which is well embedded under Section 18A of the Environment and Landscape Act, as read together with Article 3, Sub-Article 3 of the United Nations Framework Convention on Climate Change, on the need to take precaution on projects that are likely to have adverse impact on the environment. Your Honors, move with me to paragraph 16, where we see the findings of the ESIA report, which provides that Kasiri is a soft ground area that is vulnerable to landslides, as well as a potential of increasing the risk of flooding. Your Honors, we submit that the respondent failed to take this into account when setting up the project. Further, I wish to rely on the Judicial Handbook on Environmental Laws, which posits that, firstly, when an action should affirmatively be taken with respect to a particular environmental law. Your Honors, from paragraph 16, we see environmental concerns being raised, mainly that there is a high risk of land collapses. But what does the respondent do with regards to these findings? They simply do nothing. Your Honors, the second requirement is that those engaging in potentially damaging activities should have the burden of establishing the absence of harm. Your Honors, the respondents failed in this regard as they failed to establish the absence of harm, which clearly, as per paragraph 16, and the impacts resulting thereof, there were potential impacts of harm.
Also, I want to see a direct link in your submission between the actions of Talmud Limited towards the environment, specifically the emissions, and how they cause these disasters. Can you explain to this court how these actions, specifically the emissions, because we see that in this country, the Republic of Malindi emits less than 0.1% of the global emissions. Can you then submit that the Talmud Limited is the one that's emitting, or these emissions that's being emitted at this place, is the link or the causal link towards the aspects of flood, unprecedented flood, and the other climatic issue?
Thank you, Your Honor, for your question, and I am much obliged to answer your question. Your Honors, our submission is with regards to the collapse of the mines, as well as the death of the 6 children that consumed the water from River Mirenga. With regards to greenhouse gas emissions, that will be addressed in my subsequent limb of argument. Your Honors, we submit that the respondent failed to take precaution when the floods were continuing, seeing that they allowed the mining operations to still go on, which resulted in the collapse of the mines. Furthermore, they released or contaminated the water in River Mirenga, which led to the death of 6 children. Your Honor, the death of 6 children.
Counsel, are you submitting that one? We have the proof of directly leaching towards the river. And two, they also prove of the system. Kindly guide this court to the specific provisions that provide for that in the fact sheet.
Thank you, Your Honor. We submit that the respondent did indeed contribute to the contamination of the water. Your Honors, as per paragraph 23, we see that there was lime poisoning in the water at River Mirenga. Your Honor, lime poisoning results from the release of calcium oxide, which is used particularly in the mining of limestone. We submit that, as per paragraph 10, the respondents might argue that there was exposed limestone and therefore it's dissolving and therefore leading to the contamination of the water. However, lime poisoning results from calcium oxide, which is the main reagent used in the mining of limestone. And the only people that were mining limestone in this area from the fact pattern, Your Honors, is Kasiri or Tamu Limited. Moving on to my submissions, Your Honors, I wish to rely on the case of Friends of Lake Turkana versus the Attorney General and two others, a 2014 case before the Environmental Land Court, where the requirement to take the findings of an ESIA report into account were emphasized. And thereafter, the court declared that there is need to ensure robust and immediate adaptation mechanisms to prevent damage to the environment with regard to the findings of the ESIA. This was further emphasized in the case of Kenya Wildlife Service versus the Attorney General and three others decided before the ELC in 2015, where the findings of the ESIA report were further emphasized. And as per the fact pattern in paragraph 16, we see that this report was not taken into account when the project was being started.
Council, however, my reading of Article 43, 1D, tells me that you have a right to clean and safe water of adequate quantities. But I'm aware that this right is not absolute. It is subject to limitation under Article 24 of the Constitution, so long as you can show the proportionality, the necessity, and the legality test. So, my reading of the same paragraph 23 tells me that only cattle drinking water is poisoned, so the children who died were perhaps maybe drinking the cattle water. So, is there a specific requirement that, or are you submitting that the right to clean water is absolute? And if it's subject to limitation, can we say that the public necessity of the project is the one that resulted in and in the fact pattern we see the immense economic benefit of the project? Can we say that is necessary, and that is why the right to clean water, cut of clean water was limited?
Thank you, Your Honor. And I'm much obliged to answer your question. And as I do so, Your Honor, I urge this court to take note that 6 children died. 6 children.
Also, you've been seated on 6 children dying, but I'm not seeing in any place the conclusion when 6 children died.
Thank you, Your Honors. As per paragraph 23, 6 children died. Paragraph 23 of the fact sheet.
Council, kindly read paragraph 23 where the 6 children died.
It is reported that 6 children between 10 and 15 years had received medical treatment for consuming water. Additionally, cattle drinking water from the river were dying due to lime poisoning and acidic burns in the ruminant of the digestive system.
Where specifically are the 6 children died?
I wish to retract that.
Thank you. And my question now comes to the aspect of, we see this company capturing and storing, we see carbon capture and storage of 10,000 tons of carbon dioxide, right? Don't you think that we should give up to that, considering that they have shown effort in going against what would have been dangerous to the environment? Yes, probably there are emissions, but then these emissions being captured and stored. So this means that we cannot say, don't you think that we cannot say that this company's emission is now the one that is destructive to the environment?
In answering the presiding judge's question with regards to limitation of environmental rights, that is, as it regards to Article 42 of the Constitution of Malindi, I wish to invoke the case of Ken Kasinga versus Daniel Kiplagat Kirui, petition number 63 of 2017, where the court balanced between environmental rights and economic development. And it was stated that in setting up projects, the proponents have the discretion of balancing this. However, Your Honors, it is our submission that in balancing these rights, one right cannot be disregarded and the other promoted, Your Honor. You need to balance them. The key word being balancing. You cannot limit the right to a clean.
That is why I'm saying one kind of drinking water is said to be poison. So people are still having water in. So it's not absolute deprivation of the right to clean water.
It is not.
And
However,
also, just to get you, just a second, paragraph 22, we see the same company coming up with Kasiri Seven Primary and Secondary School, Kasiri Seven Educational Bursary, and also Kasiri Seven Water Systems. So we have the aspect of water systems. Don't you think that that's a balance in your submission that the equal balancing of things? Don't you think that in as much as this right is not 100% limited, this right is not 100% limited, this right is limited to a reasonable ground where they are now also providing for water systems for these people. And we also, can you respond to that?
further, to respond to both your questions, I further wish to rely on the same case of Ken Kasinga versus Daniel Kiplagat Kirui, decided before the ELC in 2017. Your Honors, in balancing the economic development and the environmental rights of the people affected by this project, what ought to be taken into account is how these rights are affected. Your Honors, from paragraph 26, we see that the right to life was affected. The right to life, seeing that 200 miners, both men and women, were killed in the collapse of the mines. And furthermore, paragraph 16 had given, I wish you learn paragraph 16 of the fact pattern, where these warnings were given, Your Honor. Our submission is that the respondents failed to take precaution in as much as they did realize.
The death of the miners, I believe that was accidental because the Tamil Limited had told these people to stop working when it was raining. It is only when the rain had ceased they went back to the mines when they died. So don't you think that is precaution enough? And in the test of necessity, proportionality, and legality, which one are you alleging was violated? For the test under Article 24 of the Constitution, it's either legality, necessity, and proportionality. So which test are you contesting is not met?
Your Honor, thank you for your question and much obliged. We submit that the test for necessity was not met, seeing that these measures were not necessary. Telling the miners to go back to work when the rains were still continuing was not necessary. Therefore, we submit that the limitation of the rights cannot be justified with regards to necessity. Furthermore, answering the judge's question on whether the respondents took precaution, it is still our submission that they did not take enough precaution, seeing as they disregarded the ESIA report in its entirety, because Professor Bakari raised issues with regards to the soft ground area, the likelihood of collapsing and the likelihood of ecosystem collapse.
Council, what precautions then do you propose should have been taken? Are you saying that when we have mines in an area that is soft ground, we should stay as if we do not have mines? So what is your solution?
Thank you for your question. With regards to paragraph 28, what we submit the government should have taken into account is the exacerbated nature of the ground due to the unprecedented nature of the floods. Therefore, they should have stopped all mining operations until the rains completely stopped.
But also, for 2 years, these mines were good for these individuals. 2 years, we don't see any issue until we see the aspect of unprecedented heavy rainfall. Don't you think, and I probably think that the respondents will bring that issue, do you think that this is not the sort of act of negligence? It's not an intentional thing. And if for 2 years this thing was effective, don't you think that we can give up to them that this thing was of just cause to the individual, or let's say the citizens, as of probably it will have happened immediately? Don't you think that we cannot say that this unprecedented heavy rainfall was reasonably foreseeable?
Your Honor, we submit that there have been warnings of these rains, and therefore the respondents ought to have taken that into account when they were setting up the project. They did not. Furthermore, we submit, or I wish to rely on the same case of Ken Kasinga, whereby it was stated that in realizing the rights under Article 42 and Article 69, what ought to be taken into account is the future generation, Your Honors. We submit that the contamination and the ecosystem collapse in Kasiri will not only adversely affect the current generation, but also the future generation. In this regard, we wish to rely on Article 69(1) sub-Article G, where the state has an obligation to eliminate processes and activities that are likely to endanger the environment. Yes.
You said that there were warnings, right? That was established. But according to paragraph 4 of the fact pattern, there is actually an incapacity to accurately monitor and forecast weather. So we can't say that the information is actually accurate.
Thank you for your question, my lady. And to submit to that, we submit that the responsibility of ensuring that they competently forecast the weather is upon them. The respondent cannot use that as an excuse to go against the rights of the citizens under Article 42 as well as under Article 69 of the Constitution of Malindi. If that suffices, I wish to move on to my second issue. The second issue pertains to whether Malindi as a state can be held liable for the transboundary harm occurring in Samaria. We submit that under international law, they indeed can be held liable. And for this, I wish to rely on two limbs of argument. That first, they have a duty to prevent transboundary harm, which is the duty to prevent transboundary harm is a customary international law obligation, having fulfilled the two requirements, that is state practice and opinion juris. And that secondly, they have an obligation under Article 4, sub-Article 1 of the Basel Convention on the control of transboundary movement of hazardous waste and their disposal, which they have ratified, or they did ratify in 1994. Therefore, they have an obligation under the said article, which, if I read in verbatim, expects states to minimize the generation of hazardous waste and to ensure that their transboundary movement is controlled. Furthermore, they have an obligation under Article 192 of the United Nations Convention on the Law of the Sea to ensure that when there is contamination of water bodies, for example, in this case, Azure Ocean, they have the obligation to ensure that the maritime or biodiversity in the ocean is protected. Your Honors, as per or rather, I wish to rely on the case concerning the Gatskikovo-Nagimaros project between Hungary and Slovakia, where the obligation to prevent transboundary harm was emphasized by the International Court of Justice. And it also emphasized the need to cooperate in the management of shared resources, taking into account a comprehensive ESIA report. We submit that the respondent did not take this into account because they knew that they have shared resources with Samaria and that contamination of these waterways is likely to affect Samaria. However, the ESIA report did not take this into account, and therefore the respondent failed in that regard. Your Honors, my second limb of argument with regard to that issue is that the respondent failed to protect the global commons, the protection of global commons being a general principle of international law, which they have an obligation to uphold as per, and it being a source of law in Malindi as per Article 2, sub-Article 5 of the Constitution of Malindi, which gives, states that general principles of international law shall form part of the laws of Malindi.
Council.
Considering that they did not share a border with Samira, in any case, do you think that they reasonably state that it was not reasonably foreseeable for them to protect, to prevent this aspect of transboundary harm, and also the fact that it was caused by unprecedented heavy rain?
Thank you for your question, Your Honor. We submit that the fact that they share the waterways and the fact that they both rely on Azure Ocean, then this in itself gives out an obligation on the respondents to ensure that they protect these global commons, this being the high seas as well as the emission of greenhouse gases, which affected the atmosphere of both countries. Furthermore, seeing that they did not conduct a comprehensive ESIA, which should take into account the shared resources, as was stated in the case concerning the Gati Kobun Agimaros between Hungary and Slovakia, then they failed in that regard, and this court should ensure that they are held liable.
So, how do you suppose they should have controlled the river? Because I believe they do not have control over where the river flows.
Thank you for your question. The way they should have control is ensuring that they do not dispose the waste in the rivers. This would have ensured.
Also, you told us in the other argument that Thermal Limited are the ones who have caused the line deficits on the water. Now you are telling us the state should control the river, which is already contaminated. How should the state do that?
Thank you for your question. And in this, I wish to rely on the Bosnia versus Serbia case that set out the test for effective control. And our submission is that the respondents or the state of Malindi had effective control to hold thermal industry into account. The test for effective control is a three-part test that was set out in the case of Bosnia versus Serbia. First is that they should have direct control over their activities. We submit seeing that they have a contract with thermal industry, then they ought to have effective control. The other part is that they should exercise oversight in the activities of thermal industry. We submit that seeing that the activities are being done in their country and seeing that they have comprehensive laws dictating how business should be conducted and how, or they have a nationally determined contribution, then they should hold thermal industry into account with that regard.
I have two questions. One on the question that your co-counsel left for you to respond, and secondly on the aspect of what remedies will we give considering that these are violation of the obligation in international law? Don't you think that it violates our jurisdiction next of giving remedies? That's the first question. The second question is on the ESCO Convention, on how the state would have conducted public participation, specifically to the issue of transboundary harm. Don't you think that it is almost impracticable to conduct this public participation? These are the questions that were left to you by your counsel, specifically on the other side, on the other edge of Samira State.
Thank you. To respond to your question, I wish to rely on the case that I have cited.
Also, I thought I noted your time was up. So, on which basis are you proceeding?
Thank you, Your Honor. I wish a discretionary minute to respond to
a minute.
To respond to
the
question. Thank you. I wish to invoke the same case that I had mentioned before in the case concerning the Kikobo Nakimaros project between Hungary and Slovakia, where the ICJ was very clear that in projects that involve shared resources, in this case, the shared waterways as well as Azure Ocean, then in setting up projects that are likely to impact these shared resources, then there should be cooperation between the two states, that is Malindi and Samaria in this case. And therefore, in cooperating, they should conduct a comprehensive ESIA report, ensuring that there is effective public participation, and as my co-counsel has submitted to this court, the public participation conducted was ineffective. Your Honors, having come to the end of my submissions,
You did not answer on the remedies. How do we have jurisdiction to give remedies, international remedies?
thank you, Your Honor. Apologies, that escaped my mind. To respond to your question, I wish to rely on my co-counsel's argument as it regards to the jurisdiction of this court with regards to section 13 of the Environmental and Land Code, where this court has interpreted jurisdiction with regards to the environmental laws applicable to Kenya. And as I have submitted, Kenya is, or Malindi, sorry, is party to the Basel Convention, as well as the United Nations Convention on the Law of the Sea. And in that regard, this court does indeed have the jurisdiction and can issue remedies with regards to the same issue, that is issue C. Having come to the end of my submissions, honorable members of the judge or of the bench, I request the court to infer our prayers from our written submissions. Thank you. I see the floor back to the bench.
Counsel for the respondent. Counsel for the respondent.
Honorable members of the bench, we wish to proceed in the next 3 minutes.
We have a function and we are behind schedule, so I'm assuming you are consenting to the same meeting with your own time that we will use 12 minutes.
Okay, we'll give you the 3 minutes.
Thank you.
That's it. 2022, we are the judge.
Yeye aliomba time before basi.
But you
But it's
So Divina Maria.
Honorable members of the bench, we are ready to proceed. Greetings, honorable members of the bench. Greetings, honorable members of the bench. My name is Austin Nganga Murithi. Greetings, honorable members of the bench. May it please the court. My name is Austin Nganga Murithi, and I am the lead counsel appearing on behalf of the respondents herein. With me, I have my co-counsel, Samba Deborah, and together we are here for the Attorney General of the Republic of Malindi, National Environmental Management Authority, and Moot Limited. We will use the time graciously allocated to us by this court to respond to the arguments posited by the petitioners as follows. I will use the first 8 minutes to argue out on the merits under the preliminary issues of issue 1 on jurisdiction, admissibility, and local standard. I will further use another 7 minutes to argue out on the merits of issue 2 on greenhouse gas emissions as well as environmental disasters. My co-counsel will use 8 minutes on our third issue to argue out matters involving transboundary harm under international law, and she'll further use 7 minutes in her fourth issue to argue out matters involving the environment and social impact assessment. Thereafter, she will conclude by stating our prayers. Unless there are no further directions, I will proceed to present my submissions.
Proceed.
Honorable members of the bench, it is our submission that this court does not have jurisdiction to handle the matters herein, that the matters herein are inadmissible before this court. However, the parties herein have local standard. I will argue out this issue threefold: on jurisdiction, on admissibility, and lastly on local standard. I'll begin with admissibility. In response to the arguments posited by the petitioners, it is our affirmation that the matters herein are inadmissible due to the lack of exhaustion of local remedies. According to Article 159 2C of the Constitution of the Republic of Malindi, we see that courts are required to observe alternative forms of dispute resolution. And while this might not look like an obligation, we rely on the case of Geoffrey Kabiru versus Samuel Mukuna Henry before the Court of Appeal in 2015, whose decision is binding before this honorable court. In this case, it was stated that the jurisdiction of a court cannot be invoked in cases where exhaustion of local remedies has not been observed. Further, in that case, Your Excellencies, further, in the case of Mohammed Ali Badi versus Attorney General and 11 others, it was held that an alternative forum for dispute resolution must be accessible, it must be affordable, it must be timely, and it must be effective. The exhaustion of local remedy, the local remedy in question is the independent and assessment mechanism under the World Bank. According to paragraph 14 of the compromise, we can see that the Republic of Malindi sought the help of the World Bank to fund the Kasiri Cement Fund project. The World Bank was able to anticipate the evolving of a dispute, and as such, they were able to have the peoples affected by projects, and which was supposed to cater into the disputes at hand with regards to the Kasiri Cement Fund project. Under the peoples affected by projects, we can see that there is an independent assessment mechanism that is supposed to take into account all the disputes with regards to the Kasiri Cement Fund project.
Also,
Yes,
you stated the Mohammed Bali case, and I think also the Jara Navia case points out 3 prongs in terms of exhaustion of local remedies. 1 is availability, 2 is sufficiency, and 3 is the effectiveness. Can you kindly guide this court on the availability, sufficiency, and effectiveness of the IAM which you provided as a means of dispute resolution in this case?
Much obliged, honorable member of the bench, and I do note your concern on the availability, on the sufficiency, as well as the effectiveness. Let's look at the issues that are posited as per the compromise. We can see that the second issue involves greenhouse gas emissions as well as environmental disasters. The third issue involving transboundary harm under international law, and the fourth issue involving the environment and social impact assessment are all within the Kasiri Cement Fund project. All these issues are arising from the Kasiri Cement Fund project. Hence, the independent assessment mechanism, it is available, it is sufficient, and it is effective to handle the matters herein.
Council, the council for the petitioner submitted that the matters presented before this court involves constitutional matters. So why can this court be persuaded that the issues presented before it is admissible, given that there are exceptions and that the doctrine of exhaustion is not absolute?
And to add that, can the independent accountability mechanism deal with the issue of interpretation in application of the Constitution and also violation of human rights? And if yes, what statute or what legal provision provides for that?
In the same council, paragraph 14 of the facts makes me wonder whether this is a dispute resolution mechanism or it's an investigative body when it says that it will receive complaints and investigate. So is it an investigative body or is it a dispute resolution mechanism?
Much obliged, honorable members of the bench, and I'll begin by answering the last question on whether this is the independent assessment mechanism is rather investigating or working towards dispute resolution. And I will refer to the paragraph 14 of the compromise, where I will read in verbatim that the financial institution established under the independent assessment mechanism would receive these complaints, begin investigations, and these investigations are working towards a dispute resolution. Hence, it is
that an investigative body in that regard, is it working towards dispute resolution in another forum, or does it say it's going to resolve the dispute?
Much obliged, my lord. And my answer to your question is that it has to do both. It has to investigate and find that the gravity of the situation is warranted under the dispute resolution mechanism herein. Hence, we submit that it is both. It investigates as well as looks for a way towards dispute resolution. Much obliged, my lord. In response to your question, my lord, on the interpretation of the Constitution and whether the independent assessment mechanism can do the same, it is our submission when answering my lady also that I do note your concern. The Republic, in the case of the Republic versus IEBC and 6 others, they were stated that there is an exception to the exhaustion doctrine. An exception to the exhaustion doctrine is where a constitutional value is at stake or where virgin matters involving the Constitution needs interpretation. And it is our submission that in as much as there is a constitutional value as averred by the respondents, which involves the right to a clean and healthy environment as enshrined in Article 42 of the Constitution, the matters are arising from the Kasiri Cement Fund project. And in order to assess the matters in totality, according to the case of Mohammed Ali Badi versus Attorney General and 11 others, in order to address the issue in totality, then in order to address the matters in totality, then the independent assessment mechanism, which was supposed to look into the Kasiri Cement Fund project, was sufficient. Honorable members of the bench, given that, yes,
I'll still ask a question. Can this independent accountability mechanism interpret the Constitution, yes or no?
No, it cannot, my
It
lord.
cannot, yes. Can it deal with issues to do with human rights violation related to the same, yes or no?
No, it cannot.
So if the respondent, if the applicant, if the petitioners in this case have provided that these issues are directly towards the violation of specific rights of clean and safe environment and also constitutional interpretation of the same, don't you think that this court should allow this matter to proceed to even give an judgment on the same, or even whether this matter is a constitutional issue or not?
Much obliged, my lord. And I do note your concern. The fact that a constitutional interpretation, as well as the constitutional value which is at stake, cannot be assessed by the independent assessment mechanism under the World Bank. However, it is our assertion that the World Bank was able to fit the criteria and find out that the that a dispute might arise within the Kasiri Cement Fund project. And in order to assess the matters in totality, the Kasiri Cement Fund project is what is giving rise to these constitutional matters. It is what is giving rise to these constitutional values. Hence, it is our submission that in order to address the matters in totality, the Kasiri Cement Fund project, the independent assessment mechanism under the Kasiri Cement Fund project was sufficient to deal with the matters.
Council, what is your definition of local remedies? Because when you tell us that an independent accountability mechanism under the World Bank is a local remedy, then I start to wonder to what extent or what is the cap to what we can be referred to local remedies.
Much obliged, my lord. And I do note your concern. A local remedy, in this case, in this instance, is an alternative form of dispute resolution, an alternative forum. And in this case, we can see that the only alternative forum is the independent assessment mechanism. In answering your question, my lord, according to this
mechanism local?
Is this mechanism local?
Yes.
It suffices as a local remedy.
Is it applicable locally or what we call a local remedy?
Much obliged, my lord. In answering your question, I will further rely on the case of Mohammed Ali Badi versus Attorney General and 11 others before the High Court, where it was held that a local remedy needs to be accessible, needs to be effective, needs to be available, and it needs to be affordable. It is our assertion that the independent assessment mechanism was sufficient, it was available, and it was effective to handle matters herein, because the matters herein involve the Kasiri Cement Fund project. And the World Bank was able to fit this criteria and establish an independent assessment mechanism to handle matters involving the Kasiri Cement Fund project. Hence, it is our assertion that it does suffice as a local remedy. Much obliged, my lord. On jurisdiction, honorable members of the bench, it is our assertion that due to the lack of exhaustion of local remedies, the matters herein are inadmissible. Hence, this court does not have jurisdiction. We rely on the case of Geoffrey Kabiru versus Samuel Mukuna Henry before the Court of Appeal, whose decision is binding before this court, where it was held that a jurisdiction of a court cannot be invoked in a matter where the exhaustion of local remedy has not been explored. It is hence our submission that this court lacks the requisite jurisdiction since the independent assessment mechanism under the World Bank was not explored. Jurisdiction is everything, and without it, a court has no power to make one more step. This was in the case of owner of motor vessel versus the Caltex Oil Limited before the Court of Appeal. Honorable members of the bench, we urge this court to take into account that it does not have jurisdiction to handle the matters herein and that the matters are inadmissible. However, on the rare occasion that this court finds that it does indeed have jurisdiction and that the matters herein are admissible, it is our submission that we wish to submit on our subsequent issues, seeing as a case was meted against us. We reserve the right to reply. Honorable members of the bench, kindly move with me to the second issue, where it is our assertion that Moot Limited cannot be held liable for the emission of greenhouse gases as well as environmental disasters, which are held to be the sole cause of the floods, of the landslides, as well as the health impacts. I will argue this out in 2 units of argument. And on the first unit of argument, it is our assertion that Moot Limited cannot be held liable since these were acts of God. According to the Blackstone Dictionary, an act of God is an overwhelming and unpreventable event which is caused by natural resources. And these natural resources are not limited, but also include floods, tornadoes, as well as earthquakes. We rely on the case of Kenya Wildlife Service versus Rift Valley Agricultural Contractors before the Supreme Court in 2015. Honorable members of the bench, it is critical to take into account that the case herein is binding before this court. In this case, it was held that an act of God cannot be prevented. An act of God is further something that cannot be prevented or avoided by due care or foresight.
Council,
Yes, my lord.
let me due to the environmental and social impact assessment done, or even conducted, I think it was Talmud Limited, which you are representing, which had actually led by Professor Bakari. Paragraph 16 showed that in the detailed report, we see that there was warning on that the surface and anomaly could destabilize the land, increasing the risk of flooding, landslides, and an economic ecosystem collapse by shifting the physical landscape of the area. Do you think that this warning was relevant, considering that in only 2 years, all these things are happening? We have a flood which was predicted. We have a landslide which killed a lot of people. Don't you think that we can tag this government as negligent, considering that there was this warning in your own social impact assessment report, which you did not take into concern?
Much obliged, honorable member of the bench, and I do note your concern. With regards to the fact that the same was anticipated in the environmental and social impact assessment, we rely on the case of Kenya Wildlife versus Rift Valley and agricultural contractors before the Supreme Court. In that case, according to paragraph 62, it was held that the criterion is not whether or not the event could reasonably be anticipated, but whether human foresight could reasonably recognize the possibility of such an event. It is our assertion that the same was anticipated in the environment and social impact assessment. However, due to the veracity of the climate change patterns, the same could not have been held to be foresighted by humans.
Council.
Yes, ma'am.
Council for the petitioners admitted that you should have taken precaution, even having received the ESIA report. So why didn't you, given that this is also one of the principles of environmental?
Much obliged, honorable member of the bench, and I do note your concern. We rely, according to the fact pattern, according to paragraph 22 of the compromise, where we see that there is the mention of carbon credits. Honorable member of the bench, a carbon credit, as defined in section 2 of the Climate Change Act, is the equivalent of 1 metric of carbon dioxide or any other greenhouse gas that is prevented from entering the atmosphere. It is our submission that Talmud Limited was able to take into account that greenhouse gas emissions might be an eventuality in this circumstance. Hence, it is our submission that they implemented adequate mitigation measures according to paragraph 52, where we can see that they were able to remove and store 10,000 tons of carbon dioxide. And there was an excess of these carbon credits. The excess of the carbon credits was used to invest into the community, where we can see that there is Akasiri Cement Primary and Secondary School, there is Akasiri Cement Springs, and there is also Akasiri Cement Educational Bursary. It is hence our submission that we acted in good faith and we helped by implementing adequate mitigation measures.
So, Council, your whole submission is that the floods are an act of God.
Yes, my lord.
You know, every time somebody says that the floods are an act of God, I agree with him completely. But when the floods start killing people, now I begin to question, because my religious belief tells me that God said He will not kill people with floods again. So floods could be an act of God, but when they begin killing people, now I question it, because in paragraph 16, you are told that there is an increased risk of flooding. Yes, floods could happen, but you are told if you do your project here, there is an increased risk. What measures do you take? There is an increased risk of landslide and ecosystem collapse. So Yes, the floods could have happened, but what measures did you take with regards to the increased risk of the city?
Much obliged, my lord. In response to your first question on your dilemma on the act of God, where it starts killing people, we rely on the Black's Law Dictionary, which states that an act of God is an overwhelming and unpreventable circumstance, which is due to the natural, which is caused exclusively by some forces of nature. Hence, it does not fit within the definition hence it clarifies your dilemma
Yes,
within the
the
definition.
forces of nature, I agree to the extent that the floods are forces of nature. But when they happen within an area where there is human input in increasing the risk, that is where now the dilemma begins.
In the same KWS case that you cited, you read on a KWS case, right?
Yes.
We had 4 prongs that were given in that case. 1 is a natural causation, 2 is a lack of possibility, 3 is that nature must be the exclusive or sole cause, and lastly, that the effect must not have been preventable by reasonable due care or foresight of the defendant. Can you submit, in relation to the question that you asked, in light of these 4 prongs, specifically on the aspect of lack of foreseeability, and also the aspect of preventable by reasonable due care or foresight of the defendant, considering that in paragraph 16, the respondents had been warned that if you start mining, we have these risks that would have been probable.
Much obliged, honorable member of the bench. And we further rely on that case, according to paragraph 62 of the KWS case versus Rift Valley before the Supreme Court. We further rely on that case in paragraph 62 of that case. According to paragraph 62 of the judgment, we see that the criteria is not whether the event will be anticipated. The event in this case is anticipated according to paragraph 16 of the compromise. However, the matter in contention is whether human foresight could have been able to mitigate this. In this case, human foresight could not have been able to do this. This is because of the erraticity of the climate change patterns. And we can see, according to paragraph 4 of the fact sheet, that there is provided that this state is developing. This is a developing state. It is relying on rainfed agriculture as well as natural resources. It is hence our submission that the criteria is not whether or not this event could be anticipated, but whether human foresight could have been able to mitigate this mission.
What was the urgency of this project? Considering that yes, probably you said that it was not possible, right? But we saw the risks that were there. What was the urgency of this project in terms of your nation? Because that's not the nation is a developing country, in as much as this is a developing country, we see that it's doing better than its peers, or especially in the east and central part of the continent. What was the urgency of it? Because in precautionary principle, we know that when a project has the probability of having imminent danger, we can just easily abandon this project. But then it went on, in fact, after the environmental impact assessment, we didn't even take a lot of time. Within 3 weeks, it was already started. What was the urgency of this project?
Council, as you answer that, recall the submissions of the Council for the petitioners on the health impact. They submitted that it does not meet the necessity test. The necessity of the project does not meet the requirement under Article 24 when limiting the right to clean water. So we haven't had submissions on the health impact.
Much obliged, honorable members of the bench. And seeing as you'd like me to exhaustively answer your questions, I seek 2 discretionary minutes to conclude. Granted. Much obliged, honorable members of the bench. Honorable members of the bench, we urge this court to take into account paragraph 4 of the compromise. Paragraph 4 of the compromise states that this is a developing state, and this is read in conjunction with paragraph 2 of the compromise, where I'll read it verbatim. It states that Malindi is classified as a lower middle income economy, despite of it being doing well in the region. It is hence our submission that the urgency of the project is based on the fact that this is a developing country, and this developing country is depending on rainfed agriculture as well as natural resources. The natural resources here involve the lime which is being mined under the Kasiri Cement Fund project. It is hence our submission that the urgency of the matter is due to the fact that the compromise says that this is a developing state depending on rainfed agriculture as well as natural resources. Answering on the question of health impacts, honorable members of the bench, I'd like to distinguish between a fact and an allegation. A fact, according to the Black's Dictionary, is something which is true, whereas an allegation, according to the same Black's Dictionary, is an unproved statement. The petitioners herein are relying on an allegation. We further rely on the section 107(2) of the Evidence Act, which provides that when a person is bound to prove the existence of a fact, which is something that is true, then it is said that the burden of proof lies on that person. We rely on the case of Nanga and another versus Owiti and another before the High Court in 2009. In this case, in page 806, it was held that where the claims under a petition involve a grave allegation, then the evidence must be cogent, it must be admissible, and the evidence must be cogent, it must be consistent, and it must be credible. It is hence our submission, honorable members of the bench, that the sun rising in the east and setting in the west is a fact. They tried to disprove that calcium carbonate is soluble in water. However, calcium carbonate, when it reacts with the carbon dioxide in the environment, leads to a calcium carbonate, hence an element which is soluble in water. It is hence our argument that these are mere allegations. These are mere allegations, and according to
Also, are you aware that scientific uncertainty does not exonerate you from taking action?
Pardon?
Scientific uncertainty in environmental matters does not exonerate you from taking responsibility with regards to any pollution.
Much obliged, honorable members of the bench. And I do not show concern. It is indeed true that these scientific proofs, these scientific facts, do not disprove us from taking liability. However, it is our assertion that the petitioners failed to prove a causal link between us and the health impacts. The limestone deposits were there. There were unprecedented rainfalls. This is a developing state relying on the erratic.
Council, the right deposits were there from when?
The is much obliged, my lord. Seeing that my time is up, I seek 1 minute.
Yes, you have it.
I have 1 minute. Thank you.
So let's be systematic. The right deposits were here from time immemorial.
Yes, honorable.
But it's clear from the fact that water was clear before. Now, after the project, water is turning milky. So let's dispose the idea that the lime deposits were there, because even in the existence of the lime deposits before, the water was clear anyway. So why is the water turning milky after you have started your project?
Much obliged, honorable members of the bench. And in answering your question, I will still rely on the compromise, where we can see that there have been rainfalls in the area. They have failed to attribute a direct causal link to the Talmud Limited, hence their submissions fail. It is our submission that in order to hold Talmud Limited liable for the limestone deposits which were there in existence, these limestone deposits could have been taken by the rainfall which have been.
That is why I'm saying the right deposits have been there. It has been raining since time immemorial. The lime deposits were not poisoning the water. Now you have begun your project, the lime deposits have started poisoning the water. So, on a balance of probability, how can the lime deposits suddenly begin to poison the water after you have begun the project?
Much obliged, my lord, and I do note your concern. However, the matter in contention is whether they have been able to attribute a direct causal link. They have not been able to attribute a direct causal link, and pursuant to section 172 of the Evidence Act, you can see that where a person is bound to prove the existence of a fact, and we've established that a fact is something that is true. Where a person is bound to prove the existence of a fact, it is said that the burden of proof lies on that person. It is upon them to prove that.
Let me ask you a question. What standard of proof are you expecting? Do you want proof beyond reasonable doubt? Because for me, on a balance of probability, I can see you could be liable. What standard of causation do you want?
Much obliged, honorable member of the bench. And we do note your concern, because according to the case of William Kabogo Kitao versus George Duo in 2009 before the Court of Appeal, it was held that a balance of probability is not the same as proof beyond reasonable doubt, which is used in a criminal matter. It is our submission, however, on the balance of probability, it is more probable than not that the limestone deposits could have been, that the limestone deposits could have been. Honorable members of the bench, my time is up. I seek 30 seconds to conclude. Honorable members of the bench, it is our assertion that there is no direct link. On a balance of probabilities, it is our assertion that the petitioners herein failed to attribute a direct causal link. And on a balance of probabilities, where we can see that it is more probable than not that this limestone, which has been in existence over a period of time, could have been distributed via any other means, because we can see that there are many rainforest in the area, and we can see that there are many channels to carry this limestone from one point to another. It is hence our submission that they failed to attribute the causal link to Talmud Limited. Hence, Talmud Limited cannot be held liable.
As you sit the floor, do you have any explanation on why then suddenly the lime deposits are, or any scientific explanation of why after the project suddenly now the lime deposits are flowing to River?
Much obliged, honorable members of the bench. While we do not have a direct, we do not have an explanation as to why suddenly the colorless water was turning milky, it is our submission that the burden of proof lies on the petitioner's hearing. And in conclusion, we urge this court to take into account causation as well as attributability of the matter, hence hold Talmud Limited, hence dismiss the petition herein since it is not merited. With that, I cede the floor to my co-counsel.
Greetings, honorable members of the bench. May it please the court, as earlier introduced, somebody is my name, appearing on behalf of the respondents, and I will be taking 15 minutes of the honorable court's time to address the last two issues, where on issue C, it is for the court to determine whether the Republic of Malindi is liable or rather responsible under international law for the environmental transboundary harm caused to the people of Samira. And it is our submission that the Republic of Malindi does not bear responsibility for the environmental transboundary harm caused to the people of Samira. And to argue out our case, we shall rely on Article 2 of the draft Articles of Responsibility of States for Internationally Wrongful Acts, which will lead me to my two limbs of argument. First, it states that for a state to bear responsibility, the following must be shown: that the action or omission of the state, or that the action or omission is attributable to the state, and secondly, that the action or omission constitutes a breach of an obligation of the state under international law. And I will start on whether the actions of the Republic of Malindi constituted a breach of an obligation under international law. And to argue out this case, I will rely on paragraph 1 of the compromise, whereas they are stating states that are neighboring, or rather, that are neighboring the Republic of Malindi, the state of Samira does not appear as one of them. And therefore, it is our submission that the harm that was suffered to the people of Samira could not be foreseeable, as they are not mentioned as one of the states that is neighboring the Republic of Malindi.
Council.
Yes.
Council for the petitioner submitted that it was foreseeable since they share a river and also a water body. So, can you respond to that?
On them sharing a river or a water body, we still stand, or rather we still submit that the harm that was suffered by the people of Samira was not foreseeable because of the following natural events that happened, as I am going to state them. According to paragraph 25 of the compromise, it was stated that the Republic of Malindi received unprecedented rainfall, and not only had it not been experienced in decades, it was also overwhelming. It was also heavy, and it overwhelmed the natural defenses of the Mirenga Valley area. Therein, the unique topography of the Mirenga Valley area contributed to the magnitude and the path of the flood, and the natural contours led the flood waters to the valley area, causing a significant rise in River Mirenga, which therefore flowed into the Azua Ocean, shared by the Republic of Samira and the Republic of Malindi. And therefore, this natural course of events makes the situation to be unforeseeable and qualifies the situation as an act of God. And according to Article 23 of the draft Articles of the Responsibility of States for Internationally Wrongful Acts, states are absolved from responsibility on issues or other matters that are caused by force majeure or other acts of God. And it is therefore our submission that we are not responsible for the harm that was caused to the people of Samira, as these events were unforeseeable and were as a result of an act of God. Secondly, on the issue of attribution, in the rare case that this court finds Talmud industry responsible for the harm that was caused, then the activities of Talmud industry cannot be attributed to the Republic of Malindi. We shall rely on Article 8 of the draft Articles of States for Internationally Wrongful Acts, which states that for the conduct of a person or a group of persons to be attributed to the state, then the state has to direct, influence, or control the activities of that person or group of persons in committing the conduct. And we shall rely on the case of Nicaragua versus USA of 1986, which was decided in the International Court of Justice, where they applied two tests in qualifying attribution. We had the strict control test and we had the effective control test, where for the strict control test, the state has to have authority over the person or the group of persons, and they have to have no independence or autonomy in carrying out their actions. For the effective test, the state has to have partial control over the person or group of persons in carrying out their activities. And it is our submission that the state neither had strict control nor effective control in controlling the activities of Talmud Limited. And therefore, the harm caused by the activities of Talmud Limited cannot be attributed to the state, and therefore absolving the state from the responsibility of the harm.
Council.
Yes, my lord.
We understand that the state who contracted Talmud Limited, right? And we also understand that through the principle of territorial sovereignty, the state of Malindi will be held liable towards anything that comes out of their state. Don't you think that some actions would have prevented this harm? Specifically on one, since the environmental impact assessment had pointed out the risks, the state would have intervened and prevented this aspect of causing environmental harm to these specific people, including the boundary harm. And two, then on the fact that the state had powers to ensure that through their contract, Tamil Limited will take all necessary precautions to prevent these aspects from happening.
Much obliged, my lord. And on your first question, it is our submission that for the fact that this harm that was caused to the people of Malindi was unforeseeable, the risks that were submitted according to paragraph 16 were relative to the Mirenga Valley area, and whatever harm that was caused to the people of Samira was unforeseeable, as they were caused due to the natural events, or rather due to the natural factors of the land, and therefore they were unforeseeable, and the Republic of Malindi could not take any.
Also, on unforeseeability, is it not foreseeable that the person downstream is affected with contamination that happens upstream?
Indeed, my lord, but the rainfall that caused all these activities are stated according to paragraph 22. According to paragraph 25, sorry, of the compromise, it was unprecedented, and therefore, the fact that it was not, or rather it had not been experienced in decades, then it could not be foreseeable that such a thing could happen, and therefore taking preventative measures would have been difficult. Much obliged. And having it, or rather saying that I have satisfactorily handled issue 3, I will proceed with the issue, or rather to issue 4, where it is our submission that the efforts we put in conducting the public participation process suffices as reasonable measures despite the challenges that we faced. According to paragraph 19 of the compromise, the challenges that we faced are clearly stated, and they include the topography of the land, the unique topography of the land, and the widely separated communities made it hard, or rather created logistical issues in reaching out to the people. Secondly, we were time-barred, and this, if affected, our interaction with the community members. And thirdly, we had limitations to the budget and the staff, therefore making us to compromise between the physical outreach, and fiscal responsibilities. Despite all these challenges that we faced, we put up reasonable measures in conducting the public participation in good faith, and we shall rely on the Moot call, local basin community, and 15 others, versus Permanent Secretary of Ministry of Energy, which mentioned a South African of 2015 of the High Court, according to paragraph